Okay, great. Thank you very much for coming today for Bright Blue's Conservatism and Human Rights project. This is our oral evidence session day. We're taking evidence from numerous experts throughout the day on a variety of themes that we're exploring in the project. And this is one element of numerous kind of evidence gathering. We've done written evidence and site visits as well, which will then help us produce new policies for a final report that the Commission will be producing in 2017. Your evidence here today will be recorded and we'll be tweeting about it, and it will be transcribed and appear in the final report. But of course, we will make clear that you are independent and that what we say is not necessarily what you would endorse, that you're here as independent experts. Now, we are quite pressed for time, and I do apologise that you've been kept waiting. Unfortunately, it's just been running over. So we're going to go straight into questions. I know that you may have done opening remarks. Please feel free to weave that in to some of the answers that we ask you. But I do apologise regarding that. So, how are things going in terms of improving the lives for disabled people? Baroness Deech.
The committee I chaired found that there was plenty of law, but it wasn't being enforced, and disabled people were being let down very badly under existing law, both European and human rights law, partly because with the cuts in legal aid and the rise in tribunal fees, individual disabled people have even more barriers put in their way when it comes to enforcing the law. Our committee is trying to move an amendment that would shift some of that burden away from disabled people onto local authorities. We also found gaps in the law because there are sections of the Equality Act that have never been brought into force at all, to do with taxis and transport, to do with landlords altering common premises to suit tenants. We found a lack of training. We found a lot of buck passing. The government says, oh, it's the local authority to do it. The local authority says it's the government. We found a great deal of heartlessness. Sports facilities, for example. Some of the richest football clubs in the country cannot seem to find the wherewithal to make their stadia more accessible to disabled people. So in a nutshell, what I'm saying is we've got enough law. Oddly enough, disability is not mentioned as such in the European Convention on Human Rights. I'm assuming that a draft, and I sent you a message saying, is there a draft, but I didn't get a response. I'm assuming that a draft would mention disability specifically. Court decisions have found that disability is in the Convention on Human Rights, most recently the Supreme Court judgment on the bedroom tax case. But it's not spelled out, so I would hope that a new Bill of Rights would specifically spell out the need to prohibit discrimination. I'm no good at drafting, but in the submission, which I have not now got time to read to you, I would have said you need to prohibit discrimination on the ground of disability, and say more positively something like this: disabled people should be given such assistance as is reasonably required, and that reasonable adjustments to the relevant circumstances and surroundings of disabled people should be made, such as will enable disabled people to enjoy the rights in this bill. In other words, I think you need to include them and to be positive about it, and always to remember, this is my final remark really, that disabled people are not a discrete bunch of people over there. All of us, even you young folk, as you get older, all of us will end up in our last few years with mobility problems, sight, hearing problems, nearly all of us. So it's a question of making sure that anybody, not just someone that you categorise as disabled, but anybody who's having a bit of difficulty can access and get all the rights that young, healthy people can have.
Okay, thank you, Baroness Deech, and we're very grateful for you preparing for that, and that was very helpful. Now, the government is quite keen on closing the disability employment gap. But the evidence we've seen seems to suggest that there's not been any real progress on that. What do you think is the sort of heart of that? Why are we not seeing the progress that we need on disability?
Just to clarify, the government has the aim of halving the disability employment gap. It's not about closing it.
Halving, sorry.
And it's an aim rather than a target.
Okay.
Well, whatever it is, we examine this in our report, and I've asked a question about this in the Lords. You cannot get half disabled people into work, and that half very much wants to go to work, unless you enable them to access transport, for example. It's no good saying go to work if your local station does not have step-free access, if the taxis sweep by won't pick you up because you've got a guide dog, if your would-be employer is unaware of or unwilling to make reasonable adjustments that you need. And the government did not agree with us that the EHRC's guidance on this should be made into statutory guidance. So they have this aim, but they won't provide the means. Transport, reasonable adjustments, documents in easy read, telephone calls to deaf people, knowing they can't cope with them and so on. You can't just have the aim, you've got to provide the infrastructure.
It can be quite difficult to include disabled people in the workforce, in jobs, as the world of work is presently organised. So there is a paramount need for more adjustments to be made by employers. It may be difficult, but it can be done. The employment situation of disabled people was very much better during the war and at the end of the war, when there weren't so many able-bodied people around to undertake the work required, and the situation has deteriorated very much since then.
Kirsty, any thoughts on the sort of progress towards halving this disability employment gap?
First of all, the fact that the government has that as a target is very strongly welcomed by disability organisations and employment support providers, and do not underestimate how having a target is important. We commissioned some research from an organisation called WPI Economics, a man called Matt Oakley, if you have come across him. The work showed that we think there's about 1.3 million disabled people who are currently out of work that actually want to work and could work with the right support. In terms of the disability gap at the moment, it's a movable feast because, of course, the number of people in work will go up, will go down. We're doing very well as a nation at the moment. But it looks like that would mean an additional 1.1 million people entering work. So a huge number there. However, the number of people with disability and health conditions out of work has stayed relatively constant, as you say. I think there's a number of issues that you might want to think about, and I was couching this in the context of the Universal Declaration of Human Rights, in particular Article 23.1 about the right to work, free choice of employment, to just and favourable conditions of work and protections against unemployment. I think first of all there is a question about access to employment support and training services, and do we have equality of access to that support at the moment? You could say Job Centre Plus is an open access entity, direct labour organisation of the government. However, if you are on employment support allowance, the average length of time that you have with an advisor per month is 8 minutes. So that is really very shocking. So then you think about access to specialist support provided by many of my members. I will be very clear, I'm a vested interest in relation to that. People like McHugh or Scope or Shorthouse or those organisations who are by and large third sector. Some of them are private sector, some are public sector, who specialise in this area. A government investment in that area has been dropping and is set to drop by 75% come April 2017. Now, government is due to invest less in what they call outsourced provision. Primarily, they think because the labour market has been doing well, and therefore there's almost a peace dividend. They don't need to invest so much in the specialist brokerage services, because actually labour market participation is extremely high. It's the highest since 1971. And they also think that their changes in benefits, particularly universal credit, which is a good thing, that if they align the financial incentives in such a way, that will provide the incentives for individuals to make the move into work. And undoubtedly some of that will be true. However, for those who have got most difficulty in accessing employment, actually they do need that infrastructure support, the specialist employment support services, and investment there is set to plummet. Two other points, if I may, that I think you might want to think about, specifically the context of human rights. The first is around the qualifying criteria, the assessment services. And at the moment, we have in place something called the Work Capability Assessment, which people with disabilities will go through, disabilities and health conditions, and that will assess whether they go into one of three groups. One is fit for work, which means they go onto a lower level benefit and are expected to undertake job search in return for their benefits. They can go into the work-related activity group, which means that the government thinks that they're not able to go into work straight away, but will be with the right support in time. Or they go into the support group, which means the government thinks actually these people cannot work, should not be expected to have to work, and therefore will just be given their benefit on conditionality. That has a range of consequences. First of all, it means that the work capability assessment acts as a gateway both to benefits but also to employment support. And that has the effect of incentivising people to actually be as ill or as disabled as possible in their assessment because they want to keep the higher level benefit. That's about face. Another issue there is that if you are in the support group, actually you don't access any employment support really. You are just, to use the horrible terminology, parked. And then the final point I wanted to make was around the protection against unemployment and the provision of in-work support, reasonable adjustments. And I think in this area we need to think about reasonableness and making sure that employers are also supported and the rights of people with disabilities are understood.
Could I make a point about employment and support allowance for those in the work-related activity group? The government has introduced a cut of 30% in the rate at which these people are paid benefit, so that their level of benefit will reduce to the same level as those on job seekers allowance. This is an enormously counterproductive measure. It's a number of charities worked together to produce a report on the impact that this cut would have, and I was associated with that report. It was very well received in the debates that took place on the reduction of the employment support allowance to those in the work-related activity group. The report was well received by many of those speaking in the debate, and really needs to be taken more seriously by the government. They are, if the aim is to halve or even reduce the disability, the employment gap, the government is really shooting itself in the foot by reducing the level at which people are supported, make it, as the report showed, make it much more difficult for people to engage in activities that will get them closer to the labour market. So it's a really misconceived measure. The government shows no inclination to revisit that cut, though that has been put to them on a number of occasions. I think their own backbenchers are becoming increasingly sceptical about the appropriateness of that measure. I heard even John Redwood on the radio the other day suggesting that the government really needs to revisit that. They really do, and I think this is a matter that it would be very good if your commission gave some attention to.
Okay, thank you very much. That's very helpful. Do commissioners have any questions?
It's just about the assessment process itself. Certainly, I don't know Dominic's experience, but as members of Parliament, we have plenty of people in our surgery who have really bad experience of the assessment process. Frankly, for 20 years, the assessment process has been dreadful. This is not new, and it's not just related to the most recent crop of reforms. How could this be done better?
I think we need to separate out access to the assessment acting as an access to benefit and then access to employment support. The fact the two are conflated means that it's a source of trauma, it has perverse incentives baked in, and means that it ends up in your post bags.
In the surgery, actually.
Mm. And what happens is that people have been through the work capability assessment, they're found fit for work, they are then sent to a programme, an employment programme, but they do not engage, because they are actually appealing the assessment. And if they engage, it's almost proving the assessment right. So then there's no engagement with the employment support. And these schemes are payment by results. So it's a whole lost opportunity, and it's got a big issue then for the provider base as well.
How would you disentangle those two?
There's another assessment as well, which is PIP, personal independence payments. And what I'm hearing from my members who specialise in this area, they're bringing something together which is really about somebody's sort of health and disability issue, and that acts as the gateway to a level of benefit. But then there's a separate assessment which is very much about their ability to work, but that does not connect through to whether they access money or not. There could be some sharing of information between the two assessments, because one of the difficulties is assessing people to death in effect. That is a difficulty. But I think we need to separate the two entirely.
I think the assessments are far too medically based too. In the assessments of people's capability for work, not nearly enough attention is paid to the actual impact of people's disability in the work situation.
Yeah.
I'm sure that's right, because we see that constantly in terms of the successful appeals against the original assessment.
Yes.
I was just going to ask whether in relation to employment discrimination or discrimination more generally, how big a problem are those with less visible characteristics in their disability? What's often I think called the, sort of the hidden disability. Mm-hmm. That's an issue which I know we touched on in the session we spoke at a conference, but is that something which the law currently does enough to recognise, and do employers do enough to recognise that in the workplace?
I think there's particular evidence of discrimination against people with learning difficulties or problems of mental health problems. They are not visible, but do constitute a very real disability, and as a result, I think they get a particularly raw deal in the employment situation.
My committee didn't have time to go into all of this, but was made aware through evidence of discrimination in education, in particular, children being thrown out of school rather than the school getting help and trying to make such adjustments as would assist the child. So we got that, and sometimes discrimination in universities as well. And I know all the complexities around that, but certainly at that level we did get some evidence of discrimination, lack of understanding of people with special needs that aren't visible on the outside.
I think there's two areas when you talk about discrimination. Is it that people with hidden disabilities are less likely to benefit from employment support or aren't accessing the employment support and therefore aren't accessing work to begin with? or is it that people who are actually in employment and manifest with this particular sort of a disability are more likely to become unemployed as a result? And I think actually both are true. I think both are true. We have National Autistic Society in membership, for instance. Neurodifference is the terminology, which covers a range of conditions, etc. And what I hear from, it's often the parents or the advocates around individuals, is that they want to be supported by an organisation that understands that particular need, and then they are able to work with the employers and educate the employers about what that actual individual has to offer. Quite time intensive, and it's not cheap either, I'm afraid. And so it's a case of who invests in that particular area, how is it funded? Often funded, I have to say, more likely to be from trusts and foundations, rather than actually mainstream government support. So that is a real concern. There's some very good pathways in place. For instance, Leonard Cheshire, another member, do work with graduates who have not learning difficulties, but sort of basically Asperger's and etc. And they put in place a supported pathway from university into the workplace. And actually, this shouldn't be a risky group because they are graduates or going to be graduates, and therefore employers should look well on But actually, without that pathway, we know the disability gap is huge. They're not accessing work. That's a relatively cheap intervention. Again, it's funded, I think, as charitable sort of money rather than anything else.
I think the public need education as well. I mean, I personally, I think twice in supermarkets, have chased an employee around, asking him questions and being annoyed that he just wasn't taking any notice. Until finally somebody else, I think another employee, tapped me on the shoulder and said this particular one was, I think, deaf-mute. How was I to know? And again, the Supreme Court, I think we're waiting for the decision. The tussle between mothers with huge buggies and wheelchair users on buses. I really do think the public need to be educated on this and to realise one day it will be you. I think that's very important.
There's a strong point I'd like to make about reducing the employment gap. There is evidence. It sometimes, since I've seen the figures, but I'm sure there is evidence that you could make a much greater impact on the disability employment gap if more attention were focused on enabling people who become disabled while they're at work to stay on in work,
yes,
than focusing all the attention on people who are not employed in the first place. The last time I looked at the figures, the evidence was that you'd be able to get 4 or 5 times more disabled people in the workforce if you focused the attention on people who were already in the workforce but all too often lose their job because they acquire a disability, than if you focus all the attention on people who are not in the workplace to begin with.
Yeah, and to be fair, the government green paper, which was released very, very recently, is very much focusing on stopping the flow, as they call it, which is about supporting people to remain in work, but also stopping people becoming disabled to begin with. Becoming unemployed when they're disabled to begin with. So, but it's quite a contentious area because it's about expectations of employers and that mix between, I suppose, carrot and stick, in effect.
Mm. And all the evidence is that once you've invested in an employee and they've learnt the business, and that actually it is in the employer's interest to reduce attrition rates through whatever cause. By far and away the most beneficial, not just economically but socially, is to try and keep people in whom you have already invested.
There's a couple of things there. First of all, what we call the sustainment rates of people who have entered work with a disability or health condition are extremely high, so over 80%. Much higher. Youngsters is the lowest. They'll fall in and out of work. But that's because of the investment of the individual, but also the employer. However, and it's quite interesting. You think back to David Frost, who was British Chamber of Commerce, did some work around fit notes, fit for work, and trying to change employer behaviour and also the role of the GP in terms of keeping people in work. David's very interesting in terms of sort of saying he doesn't think that system has worked, and he says do not underestimate the extent to which there could be some complicity between the individual who has become ill or disabled and the employer around moving them out of the workforce. And I also think that there is quite a discrepancy often between the corporate's words, their policies around disability, and basically the line managers and the local business units. There could be quite a gap there. Yeah.
One hears the same is true of pregnant women at work,
Yeah.
actually.
Yeah.
Very similar stories.
It's true. And I've seen recently cases of discrimination where towards the end of their careers, where not surprisingly, men and women want to throttle back to doing, let's say, a 4-day week, because as you get older you find sustaining the pace more difficult. Discrimination between employees who are allowed to do that and others who are not allowed to do that, with no obvious explanation. Quite a lot of discrimination against women who find themselves with caring responsibilities in the latter stages of their lives, need to throttle back to do non-full-time in order to care for elderly parents or grandchildren, and meeting with the employer's resistance to that, losing their jobs altogether, at a disastrous moment, by the way, because that is when you're in your early 60s, it is very difficult to get alternative employment. You're extremely vulnerable to losing your job at the latter stages of your career.
Yes.
I think you have to have some care for small employers. I've been a small employer. And, if you're just managing a workforce of 6 or 10 people, and one of them wants to go part-time for very good reasons, you have a real dilemma. And if you hire someone for that 1 day a week, you're then into rather more expense and difficulty and so on. With a very big employer, it's understandable, but it is hard for a small employer, with the best will in the world.
Just bear in mind as well issues around conditionality, mandation and conditionality. With universal credit, there will be the introduction of something called in-work conditionality. So in effect, you might be in a part-time role because you've got caring responsibilities for whatever else it might be. And therefore, you get universal credit top-up. There will be an expectation on you that you are taking steps to increase your earnings to reduce the universal credit top-up that you get. Now, how that manifests itself if somebody has caring responsibilities or have a health condition which means that they find it quite difficult to increase their hours without there being a knock-on effect, is an interesting area where because it's only just coming into place, we're not quite certain how that's going to play out yet.
Just looking, we've identified some key areas. In terms of legal structures, are the changes that you would like to see?
Yes, this was the concern of the committee that I chaired. We did our best to make our recommendations cost neutral or very cheap, and also to avoid changing law because of the difficulties. But there are 2 or 3 big changes, 2 or 3 core changes we'd like to see. One is to make the public sector equality duty proactive. At the moment, ministers who are making changes have to have due regard to the public sector equality duty. That is, minimising the impact on people with protected characteristics. So if ministers have due regard to it and still make a decision which disabled people see as disadvantageous, they are court-proof because they've had due regard. And we're saying the public sector equality duty should be that you must take steps towards, you must positively try and reduce those differences and take care of the protected characteristics people. The other change is the one that I have now put forward as Amendment 210 to the Policing and Crime Bill, which would require all licensing authorities, in addition to the 4 things they have to look out for now, like health and safety and protection of children, that when they're licensing premises, they should also insist on compliance with the Equality Act. The advantage of that is that it would be anticipatory. So when your restaurant's being licensed, the licensing authorities would have a look to make sure that there's step-free access and disabled toilets, rather than waiting until somebody says, oh, this is lacking, and having to enforce it. So those are two changes we like to see, as well as bringing in certain sections of the Equality Act which have never been brought into force.
I think that's very powerful, that final point. I'm very conscious of that in an ageing society we have an awful lot of infrastructure which is simply not adapted for them to cope. I mean, the most basic thing recently I noticed, it hadn't occurred to me because I'm still fit and well enough to step down from the train to the platform, but actually constituents have made me aware that the platform difference is such that if you've got a bad hip or a bad knee, you know, 1.5 foot drop is catastrophic. Can you get Network Rail to adjust the platform at any point? No, they're not prepared to do it. Even a modest measure like you see on London Underground, where there are sections of the platform raised. When I suggested that to Network Rail, dismissed it out of hand. There's no duty on them actually to address this growing problem.
We think there should be a duty. Take safe space as well. There's a great fashion for safe spaces where you mix traffic and pedestrians without traffic lights, without curbs. And there's one very near where I live at home, so I'm very well aware of that. It depends entirely on eye contact and a kind of sense of who's going to take priority. And if you're slow, if you can't see, if you can't hear, very dangerous indeed. And we think local authorities should rethink that, or at least consider when they're designing them and pedestrianised areas, how will disabled people get in there?
Yes.
They're quite widespread in the Netherlands, aren't they, safe spaces? But I wonder what requirements they're meeting under sort of disability.
Well, it's on quiet country roads in the Netherlands. The problem is where they try to introduce this in cities here. It's a daft idea and does need to be revisited. Could I just make a point about anticipatory? Ruth was talking about the need for people to be proactive in addressing the public sector equality duty. I think the implementation of the Equality Act needs to be revisited in the light of this. Under the Equality Act, service providers, people providing services, are obliged to consider that their duty to make reasonable adjustments is anticipatory. They're obliged to consider in advance what sort of changes might be needed to make their service more accessible to disabled people and introduce those measures in anticipation. That requirement doesn't exist in that form. It doesn't. The requirement on employers is not an anticipatory one. They can wait until a disabled person comes along before there's any obligation on them to make reasonable adjustments. I think it would make a significant dent on the disability employment gap if employers were under an obligation to consider in advance what adjustments needed to be made to their businesses to make them more accessible to disabled people. And while I'm talking, and we're talking about legal structures, could I just suggest this? The United Nations Convention on the Rights of Disabled People, which has been enforced for about a little over 5 years now, this is thought to make a considerable difference to the rights of disabled people. It's often said that the United Nations Convention creates an obligation. Well, it sort of does in theory, but the enforceability of such international obligations is quite doubtful, and so some thought needs to be given to how the obligations that exist in the UN Convention are translated into UK law. I mean, there are analogues of the UK of the UN Convention's obligations in some areas, like the obligation to provide inclusive education is is provided for in UK law, but there are other areas that are not underpinned by UK law. For instance, the UN Convention creates a right to independent living. That doesn't have any analogue in domestic legislation, and I think a review needs to take place of the obligations created by the UN Convention with a view to seeing what changes need to be made to UK law to make them more applicable in this country.
Thank you, Lord Lowe. Kirsty, just final thoughts, just pointing to what Dominic was saying about any changes you'd like to see in law, in policy.
In terms of law, actually, I think we tread carefully. In reality, you know, and I absolutely sort of support what is all said around me, etc. But in terms of creating new legal obligations, can often have some quite perverse consequences. We need to be very careful about. I think there's an awful lot of policy changes that we need to see, but more than anything else, I think it is long-term cultural change to a great extent, and the thing that's going to drive that is the ageing population and the fact that we are all going to know people with disabilities if we do not already. Just finally on the legal point, one thing which would be very helpful is, particularly for the Department for Work and Pensions, to think through the legal implications of its policies in advance, rather than sort of steaming ahead and then ending up in court, because that is very difficult for organisations who are operating in this space because they do not feel that they have firm ground to operate on.
Okay, very interesting. Thank you very much to all of you for sharing your time with us. It has been incredibly useful.
Thank you. Could I make just one very brief concluding observation, which really takes us back to the beginning and where we might have come in, which is the importance of human rights law for disabled people. Human rights make a substantive and tangible difference to the way disabled people are treated. It's not just political correctness, and it's important to get this on the record. I mean, there's a case of Jan Sutton, who was confined to bed for most of the day because of the low level of care being provided by a local authority. She just got 45 minutes of support a day, which was only just enough to take her to the toilet and wash her, but time to do little more. She used the Human Rights Act to get the level of support increased from 45 minutes to 4 hours a day, which gave her a much better quality of life. And there are many more examples of the kind of things that can be achieved, tangible improvements that can be brought about by human rights law, and I think it is important to get that on the record.
Yeah, thank you, Lord. No, that's very, very useful. So we are about to go into a policy formulation stage for the next few months, and the aim is a final report in about spring. So please do keep in touch. It would be good to bounce ideas off of you and for you to feed ideas into us. But thank you again for coming today.